The conviction of the accused appellant is not sustainable in law and the same deserves to be set aside. Therefore, we set aside the judgment. An order dated so and so passed by the Court of Learned Special Judge Nagaon in NDPS case number 11 of 2018 insofar as the accused appellant is concerned. In the result, the criminal appeal stands allowed.
Highly obliged.
Lordship, I beg to mention item number 14, my lord.
Non-appealing appeal. একদম সেম সেট অফ রিলিজ করে এখানে হলো এখানে 142 বলি আমার আছে ফুটফট মানে ফুটফট এনে আৰু দুবাৰ কৰি দিলো কিন্তু এনেই পিছত ভৱিষ্যতে আমি জানিব পাৰিছো কেতিয়াবা পইণ্টটো ওলাব পাৰে এইটো সেইকাৰণে চলিব যায়গে নাছে কিন্তু মই কিন্তু একোটো মানে এইটো কৰিব পাৰে নাই মই এই গিফ্টত নগলো আৰু এইটো এনেই মই নকৰিব সমাজ পিছত চলি এপিও কৰে এপিট কৰি হেৰি Yes.
Lordship, item number 14, my lord.
14. Yes.
14. Lordship, this matter may kindly taken after 2 weeks, my lord.
After 2 weeks.
Lordship.
Some putting to paper book ready. Paper book ready or what?
No, it is for the IF, lord. LCR received, my lord.
On the request of Ms. A. Mubarak, Learned Counsel for the applicant appellant. LCR is, huh?
LCR is received, my lord.
Please the case. After 2 weeks. MS A. Begum, Learned Additional Public Prosecutor. Appeal file to some for the respondent of opposite party. One state of Assam is in attendance. Post of main appeal to click hook নহলে আৰু main appeal to লিখিব A. Mubarak, heard Mr. A. Mubarak, Learned Counsel for the appellant, and MS A. Begum, Learned Additional Public Prosecutor for the respondent state. Post of as the records from the trial court have been received, office to take steps for preparation of the paper. Please, the case after 2 weeks.
Lordship, this matter may kindly taken on 6th of August, my lord. 6th of August, man, for IF.
After 2 weeks, after 2 weeks.
Must.
I beg to mention regarding item number 13 of 18 of today's list, Lordship.
Yes.
In this case, appellant number 3, who was on bail, he subsequently expired, Lordship. We have received that instruction, Lordship. Lordship, may I fix it after a week? I will produce the death certificate, Lordship. And in the meantime, a report from a
13,
concerned police station may be called, Lordship, as he was on bail.
13, 13.
18, Lordship. 18.
18.
18. In 13 also, Lordship, that
Mansur Ali.
Lordship.
What is your case?
Appellant number 3, that is Insar Ali, Lordship.
Yes.
He expired.
In the IA or in the main appeal?
Main appeal.
Main appeal. No, main appeal. Heard Mr. A. Ahmed, Learned Counsel for the appellants, and MS A. Begum, Learned Additional Public Prosecutor for the respondent state. He was on bail.
He was on bail.
IA, which one?
I
I dispose of ISN. The instant appeal is prepared by three four accused appellants, huh? 1, 2, 3, 4. Kudrot Ali, Monser alias Monser Ali, Mohammed Insar Ali, and Mohammed Nur Islam. First of Mr. Amit. Uh, and to stop. By an order dated 5/3/2020, passed in a connected interlocutory application, IA CRL 921/2019, two of the accused appellants, PIJ Mohammed Kudrat Ali alias Kudrat and Insar Ali, were released on bail after suspending the execution of the sentence passed against them. Mr. Ahmed Pera, Mr. Ahmed, learned counsel appearing for the appellants, have submitted that the accused appellant, Insar Ali, has since expired while on bail. He has submitted that he would make endeavor to produce the concerned death certificate after a week. And what about anything to
In the
do?
meantime, Lordship, a report from that police may be called, concerned police. That will
MS A. Begum, learned additional public prosecutor, is also to obtain a report from the jurisdictional police station. Officer in charge of the jurisdictional police station wherein Ansar Ali was an inhabitant. Let it be 1 week. 1 week. Release the case after 1 week. On a date to be fixed by the office.
That be your lordship.
Yes.
So for item number 4 is concerned, lordship, paper book is ready and can it be taken up for hearing?
Oh, wait, mister, or we'll go by. You are in a hurry.
Not in a hurry. Lord.
Daily list for admission, item number 1.
Yes, madam.
Lordship.
Okay, this appeal
Appeal, jail appeal, Lordship.
from jail
Lordship.
is directed against a judgment, an order dated 9/10/2023, passed by the Court of Learned Special Judge within bracket POXO, Tinshukia, in POXO case.
Lordship.
Oh, registered to appoint an amicus curiae from the panel to represent the case of the accused appellant.
Item 2.
In the meantime, তো জেলে হব judgment and order dated 8/11/2023, Court of Learned Additional Sessions Judge within bracket FTC-1, Margarita district, District কি হবো? Margarita, comma, district তিনসুকিয়া. In sessions case number 02 within bracket M of 2017. By the judgment and order dated 8/11/2023, the accused appellant has been convicted for the offense of murder under section 302, Indian Penal Code, and he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000, in default of payment of fine, to suffer further rigorous imprisonment for another for 6 months. The appeal is admitted for hearing. The case records of sessions case number 02 within bracket M of 2017 be called for issue notice returnable in 4 weeks as MS so-and-so A. Begum, additional public prosecutor, has appeared and accepted notice on behalf of the respondent state. In the issuance of notice to the respondent state, it stands dispensed with. We appoint the registry to appoint an amicus curiae from the panel to represent the case of the accused appellant. Itu na লাগে আৰু পক্ষ নহয় না
Item number 3.
Please, Your Lordship.
Hmm.
This appeal against conviction, my lord, against order dated 9/5/2024.
Heard Mr. D. Bora, learned counsel for the accused appellants, and MS A. Begum, learned additional public prosecutor for the respondent number 1, state of Assam. Full stop. The instant criminal appeal under section 374 within bracket 2, Code of Criminal Procedure 1973 is directed. আচ্ছা, anybody শুনো, এটি হলো নতুন হয়ে গেল 16 জুলাই নতুন মতে হব এপিল কৰিব পুৰণি কৰিব
সেভিং ক্লজটো আছে নহয় নতুন টাইম ৰেজিষ্টাৰ কিন্তু মনত এটা ভুল কৰি দিছে তেওঁলোকে এপ্লিকেশ্যন বিলাক আগতে ৰেজিষ্টাৰ কৰা কেছখন চব BMSS মতে ফাইল কৰিব লাগিছে এইগুলো লিখা
আমার মানে মানে দিয়া নাই কথা বলে
দিয়া নাই
আছে কি না দিছে ক'ত চাব সময়
BMSS এর নাম
নতুন 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 বেছি বুলি ক'ব নোৱাৰে ওপৰত লিখি থৈ দিব বেছি বুলি ভাৰতীয় বুজিছো ভাৰতীয় কি নামে নাগৰিক
A2
230 page 238 Immediately before the date on which this Samhita comes into force, there is any. আমার তো এটার কিসের জন্য
trial to so
ট্রায়াল তো আছে
trial including investigation
when such appeal মানে এইটো appeal there is any appeal এইটো বাদ দিলো এইটো 16 জুলাই ফাইল কৰিছে এইটো বাৰু 24 জুনত ফাইল কৰিছে ৰিপৰ্ট হৈছে 16 জুলাই যি হওক যদি জুলাই পিছত ফাইল কৰে এই বস্তুটো আহিব নে
তাকে কিন্তু হেৰিটোতো আগৰ হৈছিল
ট্ৰাইলটো হ'ব
ট্ৰাইলটো আগৰ
ট্ৰাইলটো হ'ব কিন্তু এই এপিলটো যদি ধৰে তেনেহ'লে এইটো এপিল নতুনমতে কৰে যে জুলাই পিছত ফাইল কৰে কিন্তু এপ্ৰিচিয়েটিং হেৰি CRPC 73 হ'ব CRPC 73 আৰু evidence যিহেতু কন্টিনিউশ্যনৰ হেৰি কন্টিনিউশ্যন
তেতিয়াহ'লে এতিয়াতো ৰেগুলাৰ আগৰ কেছ ইনভেষ্টিগেশ্যন চলি আছে সেইখিনি বেল এপ্লিকেশ্যন কোনখন মতে হ'ব এইটো মতেটো অৰিজিনেল মতে ৰেগুলাৰ কেছ হৈছে
ৰেজিষ্টাৰ হ'ব
এইবিলাক কেছত এপ্লিকেবল
মোৰো সেইটোৱে
ৰেজিষ্ট্ৰি কৈছে যে যিমান এপিল যিমান এপ্লিকেশ্যন ফাইল কৰিছে আফটাৰ 1 জুলাই
এপিল হ'ব পাৰে এইটো মতে এপিল হ'ব পাৰে কিন্তু এপ্ৰিচিয়েশ্যনটো সেই আগৰ মতেই হ'ব লাগিব এতিয়া নতুন প্ৰভিজন মতে যদি বেলেগ কিবা আছে CRPC এইখনত এইটোতো নহ'ব আৰু এতিয়া ধৰক ফৰ এক্সাম্পল 164 কালি যায় 281 সেইটো যদি এটা চেঞ্জ হৈছে এইটো এপ্লিকেবল নহ'ব আৰু কালি জানি যে 164 আৰু 281 CRPC শুনিছে যে ইকিজৰ চাইন লাগে 164 এইটো যদি এটা কিবা চেঞ্জ হৈছে এইটো এপ্লিকেবল নহ'ব সেইটোৱে এপ্লিকেবল or two against is preferred against a judgment an order dated 9/5/2024 passed by the Court of Learned Additional Sessions Judge number 2 Kamrup M, Guwahati in Sessions case number 99 of 2016. By the judgment and order dated so and so, the 4 accused appellants are convicted for the offenses under section 447, section 325, section 302 of the Indian Penal Code in aid of section 34, IPC. Post for the offense under section 302, IPC, read with section 34 IPC, the accused appellants are sentenced to undergo rigorous imprisonment for life, each and to pay a fine of rupees 5,000 each, with default stipulation. Full stop. For the other offenses, the accused appellants have been sentenced imprisonment for different terms. All the sentences are to run concurrently. The appeal is admitted for hearing. The case records of so and so case number be called for. Issue notice returnable in 4 weeks. As MS Begum Learned Additional Public Prosecutor has appeared and accepted notice on behalf of the respondent number 1, State of Assam. The issuance of formal notice to the respondent number 1 stands dispensed with. However, extra copy. The accused appellant shall take steps for service of notice upon the respondent number 2 by registered post AD within 3 working days.
We have also filed an IMI, suspension of sentence. That may be taken after the receipt of SCR man.
You are pressing on the
No, no,
opposition.
not to them either.
Five-
Well,
Lovely.
Item number 4 for orders.
Yes, Mr. Dhar.
The paper book is ready, Lordship. Let the matter be fixed for hearing in usual court, Lordship.
Post to JD. Three zero two.
Yes, Lord. Please, Lord.
Office note 16.5 to assess 16.5. Respondent number 302. Respondent number duly served. I don't know what it took observe with you, no? Heard Mr. Ardhor, counsel for the accused appellants. NMS A. Begum, additional public prosecutor for the respondent number 1, State of Assam, full stop. Office note dated 16/5/2024 has reflected that notice sent to the respondent number 2 by registered post with AD was duly served. Full stop. As the paper book is ready, office to list the appeal for hearing in due course.
Lovely, Lord.
Item 5.
May I please, Your Lordship? Well, this matter has come for order regarding the bail. May I pray that any other date it may come up?
Okay, Mr. Aid. As if Visas Land Council for the applicant appellant has sought listing of the appeal after
2 weeks.
2 weeks. MS Begum, learned additional public prosecutor for the opposite party, State of Assam is in attendance and has no objection to the said case. Post the list case after 2 weeks, as sought for by the Land Council for the applicant appellant.
Item 6 to 8.
Ah, 302
Yes, Lordship.
or what? Offense?
302.
302. Yes, how many?
Lordship, we have received
Separate appeals.
separate.
1, 2, 3. Yes, who is for item number 6?
I am MS P. Soika on behalf of Mr. D. Talukdar. We have received the paper book.
And MS T. Begum, you are amicus in item 7. And Mr. Ganguly, amicus in item 8. All of you have received paper book. Okay, hearing. Heard MS P. Soika, learned counsel, appearing for Mr. D. Talukdar, learned counsel for the appellant in 6, MS T. Begum, learned amicus curiae for the appellant in 7, and Mr. A. Ganguly, learned amicus curiae for the appellant in 8, and MS A. Begum, learned additional public prosecutor for the respondent state, learned counsel for the parties.
I have recorded evidence of some items. No, so party of this vaccine.
Okay. It will show me there. Okay. That's not so good to do, Nikki. नहीं अफेक्टिव ऑर्डर लिखे भी नहीं लिखे the as the paper book is ready, office to the registry to list the appeal for hearing in the usual course. Post of the appeals are to be listed before a court without one of us, within bracket, R. Pupa.
Online classes.
Item number 9.
What is the learning council for a participation? Huh? I have submitted that they have received a copies of the paper book.
May it please your lordship.
Yes,
Lordship, I had already filed the affidavit of assets and liabilities earlier. Yesterday, I have received the copy filed by the appellant.
Service report.
sounds good.
Question complete.
Yes,
Lordship, service is complete. In fact, Lordship, after receipt of notice from the honorable court, which was sent by us, my lord, parties arrived here, met me. So I have, through my junior, sent her to the Legal Services Authority. And a letter has been issued, but I think, I don't know whether it is communicated to the Learned Council. Why do you have not copy? Is that? Why, sir?
I say,
Why, sir?
item 10. B. Haldar. B. Haldar,
Yes, sir.
or Mr. B. Haldar. Learn it. Legal aid council
Legal aid council.
for the accused appellant and MSP Bhuiya, learned senior counsel and additional public prosecutor for the respondent number 1, State of Assam, post of MS Bhuiya, learned additional public prosecutor has submitted, on the basis of a report dated
Yes, sir.
15/7/2024. Received from the officer in charge, Lanka Police Station, that the notice upon the respondent number 2 has been duly served. Full stop. By obtaining RTI of the respondent number 2. A photocopy of Suborna Mondal, Arati Mondal, LTA বাদ দিয়ক। Arati Mondal. Who is Arati Mondal?
Informant, my lord.
Huh?
Mother.
But respondent number 2 is Suborna Mondal.
Suborna Mondal. To the informant.
Aruti Mondal, wife of Govinda.
Huh?
Grandmother Suborna Mondal.
Notice was meant for whom?
This
Aruti Mondal,
Huh?
that calm impression is there.
Why Arati Mondal? He made the respondent number 2 one Suborna Mondal. Is it not?
Suborna Mondal is the informant in the case.
Huh?
She was the informant in the case.
Here, my lord, name of the informant is Aruti Mondal.
Huh?
In our case, appeal.
Dilip
No,
Mondal.
Suborna.
এখন দিলীপ সরকার নহয় জানো?
There is a Moro Dilip Sarkar.
Who is Suborna Mondal? So else.
Dilip Mondal.
Lordship, I think I'm making some, I'm sorry, this,
Huh?
as regards item number 12, I'm making a sure.
Huh?
She is appearing in item number 10. It
10 to 10 to Dilip Mondal.
was it there?
In the item number 10, appellant is Dilip Mondal.
And your police station is Abhayapuri. This is
Abhayapuri.
Lanka, madam. The documents are of Lanka.
Deep
My learned
Sarkar.
This Subarna Mandal is from Abhayapuri police station.
My learned
And
friend is
this document is Lanka.
taking up the file of item number 12. That is why.
That was- It is as item 12. I'm sorry, my lord. 10. 12. No. 10 to number more appearance.
Right. In the item number 10, Lordship, kindly come peruse the order dated 13/5/2024. In that case also, the notice was not served upon respondent number 2. And there was a
Right.
direction to
Put to PS.
it was Abhayapuri to
Abhayapuri police station.
deliver.
Oh, Lordship, I am not aware of it. I may be granted some time. I'll take steps.
We have.
Get a copy from.
Objection or
Yeah.
Item number 11.
Whatever.
My lord, in this case, service is complete and there was a prayer from the state to file objection regarding bail prayer. They have not filed it, my lord.
PP by order responding. Respondent number 2 appeared or not?
Yes, yes.
Counsel is not found available. Yes, objection. Mr. S.C. Vistas, heard Mr. S.C. Vistas, learned counsel for the applicant appellant and M.S.B. Bhuyan,
Lordship,
learned as senior counsel and additional public prosecutor for the state by M.S. M. Chakraborty, learned counsel for the opposite party number 1, State of Assam. Further. কৰি আছে আগতেতো কৰিছিল আগতেতো আগতেতো মই অবজাৰ্ভ কৰি দিলো এইটো লিখিছো
mail or copies.
লিখিছিলো কিন্তু এবাৰ ষ্টাৰ্টিং কৰিব দিছে চাৰি এবাৰ
What's that?
এইটো থাকক তাৰ এডিশ্যনেলি ষ্টাৰ্ট কৰি দিছো এইটো তাৰমানে নিজৰ হেৰি কৰি পেলাই হ'বলে নহ'লে কাৰণ নটিছ নাজানোতে উপস্থিত হ'লে হ'ব লাগে
Lordship, Miss
2 weeks.
S.H. Pora, she appeared in the last occasion. She has a personal difficulty today.
But objection is not filed.
Yes,
Not
madam.
filed.
So after all,
So MS Bhuyan, further 2 weeks.
2 weeks.
The additional public officer has prayed for and is granted further 2 weeks time to file an objection to the interlocutory application under section 389(1) CRPC. Please the case after needed to be fixed by the office.
I pray, my lord, 5th of August.
2 weeks, 2 weeks.
Item number 12.
এটি ডিস্ট্রিবিউট করে ভালো লাগবে নহলে যদি ঠিক করে আমি সময় এগুলো ফিক্সটা লাগিয়ে আছে
Lordship, I'm reiterating my submission in item number 12, which I've made in item number 10. So office, legal services authority has engaged, a communication has been sent to us. Like, can you read? Whether he was
I've
communicated.
been pleased to engage you. Okay, Mr. Peace, okay. Therefore, Arati Mondal. Okay. Heart, MS.
It's Katania.
Lordship, but I am not aware of whether it was communicated duly or not. It was sent to us via WhatsApp to my junior. By the
But
legal service.
service is
Right,
complete.
complete.
True, my lord.
Yes.
My lord, 2 weeks time may be granted for filing.
Further.
My lord, I am for the appellant.
My lord, we have got the paper books, my lord, recently, my lord. That's why-
Paper book you have got.
My lord, we have received. So, my lord,
Paper book is ready, it can be listed for hearing itself anyway.
Today, my lord,
Objection.
listed for consideration of IA, my lord.
Okay.
That has been
You want to file objection?
Objection on IA, my lord. 2 weeks, my lord. You can
Yes,
see
Mr.
it.
Borua.
My lord, actually, on last occasion, my friend appeared, my lord. Possibly,
Appeared, and their first appearance was
Yes.
on the previous date.
and he is in jail.
Some
so-
leverage,
Yes,
it happens also in your case also,
my lord,
sometimes.
some,
Mr. B. Borua, learned counsel for the applicant appellant, MS. A. Begum, learned additional public prosecutor for the opposite party number 1, state of Assam, and B. Mr. B. K. Singh, learned counsel for the respondent number, opposite party number 2, that's in comment. Full stop. Mr. Sen, learned counsel for the opposite party number 2, that's in comment, has prayed for and is granted further 2 weeks time to file an objection to the instant interlocutory application under section 389 CRPC. Raise the case after 2 weeks.
Highly obliged, my lord.
my lord,
I-
can-
You receive paper books?
My lord. I have it.
It is submitted by the learned counsel for the parties that they have received the copies of the paper.
may I pray, can it be on my lord?
No pics.
Obliged, highly obliged.
Item 16.
এইটো মই প্ৰত্যেক হঠাৎ নামটো মনত পৰিব ৰাতিপুৱা এই ৰেকৰ্ডটো দিয়কচোন ৰেকৰ্ডটো দিয়ক এইটো মই prepare কৰিছো ৰেকৰ্ড নহয় এই প্ৰজেক্টৰ এই ৰেকৰ্ডটো
Lordship will ask for the Aadhaar card.
1 minute.
Lordship, this case is gone.
1 minute. In their bail application. I'll not take further participation in this proceeding. Suddenly, in my mind struck, these are the orders, part of the record. List the case before a bench without one of us, more number.
An urgency may be shown because of his health. The Lordship can indicate.
As the learned counsel for the appellant has shown, has expressed urgency from our office to list the case expeditiously. That formation of a bench will be a
But
problem.
I understand, madam, but still an observation is better. Obliged.
তেখেতে গুচাই দিব আৰু গোটেইকেইটা বিল কৰিছিলো তাৰ ৰঞ্জন বৰদলৈ চালো মই ৰঞ্জন বৰদলৈ তাৰটো ৰিজেক্ট কৰিছিল বাকী চবৰে দিছিল তাৰপিছত নেক্সট টাইম আকৌ তাৰ ঘূৰালে 2 মাহ পিছত এইটো
Supplementary list item number 21.
এই জুবেনে এই যে কালি যে আমি লটো এইটো যে লটো এই law টো। এই যে রিপোর্টটো আহিলে না, এইটোকে রিপোর্ট আহিছে নি? এইটো আহিছে কোনটো? এইখন নাই মোৰ ক'ত বলবা কোনখন আছে চাওঁ। 21 আছে চাওঁ। Call list খন। জুবেনিলৰ ৰিপোৰ্ট এইটো ইনকুৱাৰী এইটো যে ইনকুৱাৰী ৰিপোৰ্টটো লৈ পেলাই এইটো এভিডেন্স ল'ব নালাগিব মেডিকেল বৰ্ডৰ কোনো এটা ল'ব নালাগিব মেডিকেল বৰ্ডৰ কাৰণ কিছুমানত এনেকৈ জিকাই কৰি থৈছে মেডিকেল ৰিপৰ্ট এইটো মেডিকেল ৰিপৰ্ট চিভিল হস্পিটেল হাত চাতৰ লৈছে নাই কি লৈছে নাই কি লৈছে কি নলৈছে ক'ব Learned amicus curiae for the accused appellant and Mr. M.S. Abraham, learned additional public prosecutor for the respondent state of Assam post of. The learned counsel for the parties have submitted that they have received a copy of the inquiry report. And along with the report, Lord, it took my to do derivative, file to it.
Lordship has fixed this matter on 29.
29,
Obliged.
huh? You are not standing yourself. Find out whether there is any standard operating procedure or guidelines regarding composition and constitution of a medical board. Who should be the members of a medical board, right? Any specialist? Because maybe there may be a medical board, but whenever opinion is required on a particular aspect, then a member can be co-opted from that particular field. Right? Entire thing. Or call Mr. B. Gogoi.
Item number 22.
It was it. Literary because police to the intelligent capacity. Detailed discuss question. Discuss question. Before the clear mental incapacity to the didn't write to show. Yes,
Lordship,
Ananja Reddy.
yes. And I'll be relying on another judgment 2007 361. But it's a ordinate bench,
2000.
7 361. para 18 onwards.
One.
Ram Singh versus Sonia.
Para
18 minor, 18 onwards.
18.
18, 1-8. Turning now to the next submission of learned counsel appearing on behalf of the accused as to judicial confession made by A1 before PW 62. It would be useful to refer to the relevant provisions in a criminal procedure code that deal with a recording of a judicial confession by a judicial magistrate and see whether the judicial confession recorded by PW 62 of A1 is according to the procedure prescribed by these provisions, or whether any violation thereof has been made by the magistrate while recording it. The relevant sections in CRPC are sections 164, 281, and 463. Then, Your Lordship, this one quotes have been given. Then para 23, on 24/2001, upon receipt of an application moved by Superintendent Police for recording dying declaration of A1 by Magistrate DSP Mansingh, who partly investigated the case, approached the Chief Judicial Magistrate Gizar. Para 23, my lord. On 24/8/2001, upon receipt of an application moved by Superintendent Police for recording dying declaration of A1 by Magistrate DSP Mansingh, who partly investigated the case, approached the Chief Judicial Magistrate Hisar, who in turn marked the said application to Pradeep Kumar PW 62. On his presentation to PW 62 by DSP Mansingh at 10 p.m. the same day, both PW 62 and DSP Mansingh left for Janta Hospital, Barwala. After reaching the hospital and before recording the statement, PW 62 first sought opinion of Dr. Anant Ram as to the fitness of A1 to make statement. As in the opinion of PW 32, A1 was fit to make statement. PW 62 proceeded to record it, which in question and answer form. It appears from Exhibit 187 as well as from the question and answers which were put to A1 and PW 62 warned A1 that she was not bound to make any confessional statement, and in case she did so, it might be used against her as evidence. In spite of this warning, A1 volunteered to make the statement, and only thereafter the statement was recorded by PW 62. In the certificate that was appended to the said confessional statement, PW 62 has very categorically stated that it explained to A1 that she was not bound to make a confession, and that if she did so, any confession she would make might be used as evidence against her, and that he believed that the confession was voluntarily made. He further stated that he read over the statement to the person making it and admitted by her to be correct, and that it contained a full count of the statement made by her. It has been further stated by PW 62 in his evidence that at the time of recording of the confession, it was he and PW 32 who were present in the room, and there was neither any police officer nor anybody else with the hearing or side when the statement was recorded. It was also appears from the evidence of PW 62 that it took about 2.5 hours for him to record the statement of A1, which runs into 5 pages, which is started at 10:53 p.m. and ended at 1:28 a.m., which goes to show that A1 took her time before replying to the questions put. PW 62 has also stated that she had given the statement after taking due time, after understanding each aspect. It also appears that he was satisfied that she was not under any pressure from any corner. Therefore, it is evident from the certificate appended to the confession statement by PW 62 that the confession statement was made by accused voluntarily. Of course, he failed to record the questions that was put to him to the accused whether there was any pressure on her to give a statement. But PW 62, having stated in his evidence before the court that he had asked the accused orally whether she was under any pressure, threat, or fear, and he was satisfied that A1 was not under any pressure from any corner, that in the room in which the said confession statement is recorded, it was only he and PW 32 who were present and none else, and that no police officers were available even within the precincts of the hospital. The said defect, in our view, is cured by sections 463 as the mandatory requirement provided under section 164(2), namely explaining to the accused that he was not bound to make a statement, and if a statement is made, the same might be used against him, has been complied with, and the same is established from the certificate appended to the statement and from the evidence of PW 62. Therefore, in the light of our discussion above, we have no hesitation in holding that a judicial confession having been recorded according to procedures set out in section 164, read with section 281, and a defect made while recording the same being curable by 463, it is admissible in evidence. We now advert to the decisions relied upon by the learned counsel appearing on behalf of the accused. In Nazir Ahmad, the accused, who was charged with dacoity and murder, was convicted on the strength of a confession said to have been made by him to a magistrate of the class entitled to proceed under the provision of section 164 relating to the recording of confession. The confession was not recorded according to the procedure, and a record of the confession was not available as evidence either. The magistrate, however, appeared as a witness and gave oral evidence about the making of the confession. He stated that he made rough note of what he was told, got a memorandum type from the typist on the basis of the rough notes, and thereafter destroyed the rough notes. The said memorandum signed by him contained only the substance, but not all of a matter to which he spoke orally. The recording magistrate in the said memorandum just above his signature appended a certificate somewhat to the same effect as that prescribed in section 164, and in particular stating that the magistrate believed that the statement were voluntarily made, as there was no record in existence at the material time. There was nothing to be shown or to be read to the accused, and nothing he could sign or refuse to sign. The Judicial Committee held that the oral evidence of the magistrate of the alleged confession was inadmissible. The magistrate offered no explanation as to why he acted as he did, instead of following the procedure required by section 164. When questioned by the session judge, the response of the accused was the direct and simple denial that he had ever made any confession. The Judicial Committee, considering the abject disregard by the magistrate of the provision contained in section 164 of the code, observed that where a power is given to do a certain thing in a certain way, the thing must be done in that way or not at all. Nazir, in a case where recording magistrate did not at all follow the procedure prescribed by in section 164 of the code, as a result of which he violated the provisions thereof. Whereas in the case on hand, the omission that has been made by the magistrate in his failure to record a question that he asked the accused whether she was under any pressure, threat, or fear to make confession in the confessional statement, and the answer given by A1 in his evidence before the court, PW 62, stated that he asked A1 whether she was under any pressure, threat, or fear, and after he was satisfied that she was not under any pressure from any corner, he recorded Lordship, memorandum. He recorded the memorandum that was appended to the confession statement of A1 that he believed that the confession was voluntarily made. In our view, Nazir has no application to the facts in present case, and a failure of PW 62 to record the question put and the answer given in the confession statement has not caused prejudice to the accused in a defense, and is a defect that is curable under section 463. In Pritam, the accused was arrested on 17/6/73, and when produced before the magistrate on the following day, he was sent to police custody, where he remained until 22/6/1973, and thereafter he was sent to judicial custody. Upon being produced before a magistrate on 25/6/73 for recording his confession, he was given 2 hours time to reflect. After cautioning the accused that he was not bound to make a confession, and that if he did so, it might be used against him, the magistrate went on to record his confession. Failure of the recording magistrate to put questions to the accused to satisfy himself that the confession was voluntary, so as to enable him to give the requisite certificate under subsection 4, was struck by this court as flagrant violation of the provision of 164(2), and in utter disregard of the mandatory requirement of the said section. Preterm is a case where the accused remained in police custody for 6 days immediately before the recording of his confession by the magistrate, and therefore could be said to have been pressurized, tortured, and harassed by the police. In such a situation, omission on the part of the recording magistrate to put a question to the accused to satisfy himself that the confession was being made voluntarily can be said to be flagrant violation of law. However, In the case in hand, A1 was removed by the police from the place of occurrence to the hospital in the morning on 24/8/2021, where she remained until her arrest by the police in the evening of 2001. It was at 10:58 p.m. on 24/8/2001, that is during her hospitalization, that PW 62 recorded her confession statement after cautioning her that she was not bound to make any confession and that if she did so, it might be used as evidence against her. PW 62 in his evidence has stated that it was only after administering the above caution and satisfying himself that A1 was making the statement voluntarily that he proceeded on to record her confession. It also appears from his evidence that no police official was present either in a room in which she recorded the confession statement of A1 or in the hospital. Therefore, in the absence of any evidence to show that she was under direct or indirect vigil of the police authorities during her hospitalization, and she having already confessed a crime in her suicide note, the omission on the part of the recording magistrate to record the question and the answer given in the confessional statement cannot be said to be flagrant violation of law, especially in view of the fact that the recording magistrate has stated in his evidence that he orally asked A1 if she was under any pressure, threat, or fear, and it was only after satisfying himself that she was not under any pressure from any corner that he recorded her confessional statement. In the certificate that was appended to the confessional statement as well, PW 62 has stated that he believed that confession that A1 made was voluntary. In our view, the defect committed being curable under section 463 has not injured the accused in her defense on the merits and that she duly made the statement. Para 26. Similarly, in Tulsi Singh, also relied upon by the learned counsel for the accused, the recording magistrate did not explain to the accused that he was not bound to make the confession and that if he did so, it might be used against him. Nor did he put any question to him to satisfy that the confession was being voluntarily made, although an endorsement to this effect was made by him in the certificate that was appended to the confessional statement. This court, while setting aside the conviction and sentence recorded against the accused under section 302 IPC, held that the special court was not at all justified in entertaining the confession as a voluntary one, observing that mere endorsement would not fulfill the requirements of subsection 4 of 164. This case too has no application at all to the facts of the present case for two reasons. Firstly, in this case too, the appellant remain in police custody for a week, and secondly, this case in which the recording magistrate neither explained to the accused that he was not bound to make the confession, and if he did so, it might be used against him for nor satisfied himself upon questioning the accused that the confession being voluntarily made. In the case on hand, PW 62 in his evidence stated that he did ask the accused the question whether she was under any pressure, threat, or fear, and only after satisfying himself that she was not under any that he proceeded on to record her confession statement. Therefore, in view of our above discussion, the three decisions relied upon by the learned counsel of the accused in Najir, Pritam, and Tulsi are of no help to the accused. In Babu Singh, reliance on which has been placed by Mr. Tulsi, appearing on behalf of the appellant in criminal appeal number 897, so three judgments of the court while dealing with the question whether non-compliance of provision of section 164 or section 364 is defect, which could be cured in section 533, section 463 of the new code observed by SCR. Then that quote has been quoted, my lord. Then para 29. After observing that the confession is duly recorded, the bench proceeded to discern from the factual matrix of the case whether the confessions are voluntary or not, and taking note of three unusual features for question recorded, namely that the accused escaped in the police custody even after the substantial part of the investigation was over, that the confession was recorded did not indicate as to how much time the accused was given to the magistrate before any made their confession, that the magistrate who recorded the confession had taken part in assisting the investigation by attesting recovery memos in two cases. Lordship, I'll be relying on para 32. In state of UP versus Singhara Singh, a three-judge bench of this court observed that if the confession is not recorded in proper form as prescribed in section 164, Redo 281, it is a mere irregularity which is curable by 463 on taking evidence that the statement is recorded duly and has not injured the accused in defense on merits. it is observed that what section 533 of the old code, my lord, section 463 of the new code, therefore, does it's a permit oral evidence to be given to prove that the procedure laid down in 164 had in fact been followed when the court finds that a record produced before it does not show that that was so. If the oral evidence establishes that the procedure had been followed, then only can the record be admitted. Therefore, far from showing that the procedure laid down in section 164 is not intended to be obligatory. Section 533 really emphasizes that the procedure has to be followed. The section only permits oral evidence to prove that the procedure had actually been followed in certain cases, but a record which ought to show that does not on the face of it to do so.
So
See?
oral evidence is clear.
Here, except one
Oral
point, my
evidence
lord,
is clear that procedure laid down was not followed. So far as the sub,
signature is concerned.
yes.
That is there, that final point is there,
And
my lord.
this,
Whether
this,
it's a
this
mandatory,
part, this kind of, this signature
my lord,
is perceptible to the eye
my lord,
that
lordship,
something, yes, it could be said that I asked,
my lord,
he said
my
so
lord.
and so, so and so. But so far as signature is concerned,
Concerned, yes,
it has to appear on the face of the
Face of-
record.
Yes, in absence of the procedure.
So
lordship,
that, to
defect in the
that
procedure.
extent, Dhananjay is clearly on that point.
That is there, but I'll be,
This has gone here and there, right?
lordship, may I
We
cite one
appreciate
state of UP Singhara Singh,
Singara Singh, yes,
3 judges bench.
yes. That paragraph 10
Yes,
of Singara,
my lord. And one more factor, my lord. There is no cross-examination to that effect, my lord. That the magistrate was in favor of the prosecution side, my lord. He's a judicial officer exercising
No,
judicial power.
but
Cross-examination on that
cross
point is.
clearly extracted out in the cross-examination.
So only the signature part, but
Yes.
biasness, lordship,
No,
There is no
nothing.
question of
really,
bias.
biases is
because
not,
he's performing his judicial function under.
that is not imputed. That
My
we are
lord.
not, nobody is imputing
My
that.
lord. So, lordship, and the.
Now, otherwise, the law is privy council, what is to be done in a particular manner, that
Has
must
to
be
be
done
done.
in that particular manner, in no other manner.
If the judicial confession goes, my lord, the extrajudicial confession still remains.
Which one is extrajudicial confession?
Judicial confession.
It was made to my lord, PW 2. According to him, extrajudicial confessions made before the neighbors.
That neighbors were not
The
examined.
neighborhood people.
This
Neighborhood people.
This
of my
Binoy
sister.
Deka and Nilamani Deka were brothers.
uncles.
Both came much after the
No.
occurrence. And Nilamani Deka,
Lordship, last line, he says, the neighborhood people told him. So it is totally hearsay. It is not
hearsay,
confession.
this is
It
hearsay.
is not
None
confession.
has been examined.
No neighborhood people were written.
Lordship, this is a curable defect or whether it goes against the prosecution, the root of the prosecution is.
But this judgment itself shows that this is not,
Probably.
that is on specifically on the
Shankariya para 51.
para 51. Which one is para 51?
Citation to question.
78.3 SCC 425. Another circumstance which reinforce the conclusion about the confession being voluntary is that it was not retracted at the earliest opportunity. The confessions recorded on June 4, 74, the trial of the accused comments on January 10, 1975, when charges were framed and read over and explained to the appellant by the session judge. At a trial, he was defended by Shri
Which
Gopal.
paragraph?
Para 51, minor.
This extract, this one.
Oh, no, no, Shankaria, 78 3 SCC 435.
Singhara, Songkoria or Singhara.
Shankaria versus State of Rajasthan. Which is it?
Ram Singh.
I
Ram
slowly
Singh.
read out, my lord.
You referred to Ram Singh. You have referred to Dhananjay Reddy.
Ajit, it is. Probably today we'll meet.
What is the citation?
Small
What is the citation?
78 3 SCC 435.
78.
3 SCC 435. What did you say? No, copy na hai na? Para 51, madam.
Okay.
Another circumstance which reinforced the conclusion about the confession being voluntary is that it was not retracted at the earliest opportunity. The confession was recorded on June 14, 1974. The trial of the accused commenced on June 10, 1975, when charges were framed and read over and explained to the appellant by the session judge. At the trial, he was defended by Sri Ganpat Ram, who, as already observed, was an experienced lawyer. The trial dragged on for several months because witnesses were examined piecemeal on different days. The prosecution evidence was closed on June 14, 1975, and the accused was then examined under 313 CRPC. It is during such examination the appellant for the first time retracted the confession and took up the plea that he had made it under duress of the police. After bestowing our best consideration to all the questions bearing in point, we are of the opinion in the circumstance case, the High Court was right in coming to the conclusion that confession had been voluntarily made by the Sankaria accused. So in our
Lordship,
case, Lordship,
retraction will come.
no point has been raised except in 313.
Lordship, retraction will come only if the confession is correct. The confession itself is not correct. So there is no question of going to retraction here. An extrajudicial confession, there is no extrajudicial confession.
See the testimony of PW.
15, Magistrate, my lord. 15.
Page 20.
Page.
28 and 28A.
See the chief.
Chief.
I'll read, Lordship.
1, 2, 3, 4, 5, 6, 7. 7. Accordingly, on 4/9/2017, was produced by
Investigating officer.
Then thereafter, Lordship.
then thereafter only the day's reflection time.
Same
Lordship,
day
but
he said-
Sankaria goes in, there is no formula, Lordship. It's flexible, my lord. Then a straight jacket formula is not there, that this much of time has to be there.
No, no. Then, though he was sent to judicial custody, but on the day, he was produced by the investigating officer.
On the day confession was made, phone 9.
No, thereafter, my lord.
No, phone 9.
Thereafter, reflection only for the day's time,
Kidnahani confession.
but
to this.
it was
Accused
because
is placed-
authorities are there, he should be out of the purview of clutches of the investigating officer.
My lord.
And many a times it was seen that from jail goes to the police lockup, then to the court.
Lordship,
Many a times
My
there
lord.
were cases
my lord.
that from jail, investigating officer takes
They-
him out,
they-
takes him to the police station, then to the court.
Court.
So this is the magistrate's version that he was produced by the investigating officer. This is one more element.
Because they bring all the accused together to have a convenient hearing.
Hmm?
അതെന്താ പ്രൊഡ്യൂസ് ചെയ്യുന്നത്?
It should be by jailor. Jailor,
Maybe, my lord.
not by
Police.
Police.
jail service is different, I think.
My lord. Police
Jailor
are-
is not police service.
Police are very happy one alage. Confession was.
Police, okay. No, engagement, in the investigating officer, under the classes of investigating officer, तो वो बहुत balance हो जाए. बहुत कोई से होता है. तो कहते हैं boy की पुलिस में मिली हो. तो हम कैसे भी बोल कैसे. আপনি কি দিতে পারেন নমক দিয়ে এইটো বাৰু হয় কিন্তু এটা লিগেল আৰু মৰেল কথা যিটো ধনঞ্জয় ৰেড্ডি কৈছে Heart MSRD Mujumdar, learned amicus curiae for the accused appellant, and MS B. Bhuyan, learned senior counsel and additional public prosecutor for the respondent state. Post of arguments are heard, judgment is reserved. Yes.
Highly obliged, Lord.
Yes, Mr. Bhuyan, Gogoi. Is there anything, any guideline, standing instruction regarding composition and constitution of a medical board? Suppose medical board is, suppose court asks constitution of a medical board to determine on a particular aspect. In this case, determination of age, whether he is juvenile or not juvenile. Child in conflict in law or not. So is there any SOP?
No, to my knowledge, there is no such SOP. But my lord, whenever such direction is given, and considering the my lord ailment mentioned in the order, they used to constitute the my lord board
Right.
in the medical college, if it is directed for the medical college.
And for,
Some professor and all my lord, the head of the
for
department.
districts?
Districts, my lord, it will be my lord again the superintendent of the civil hospital. But my lord, best will be my lord if it is there in a medical college, because the professors, head of the department, they can my lord, they are the my lord best person, being the super specialist. or
And is there
specialist.
anything central government guidelines, pending instruction?
I can have the instruction, my lord, I will just provide it.
Because suppose direction is definitely for considering one particular aspect.
Yes, sir.
Here in this case, to determine the age.
Lordship.
And age to be determined on the basis of ossification test
And
and other advanced
Yes.
tests.
Sir, radiology department is to my lord look into. that.
Radiologist
To my
plus
knowledge.
the
Dental and bone and all.
bone and all. So from the report here, we do not know whether any radiological,
My lord, if it is in the district level, at least I can say, my lord, in civil hospitals and all, probably radiology is not there. Radiologists are not available at this, the dart of some doctors. So preferably it will be, my lord, medical college and hospital if it is there. Then, my lord, all this. If any second opinion is required, my lord, lordship can direct.
no, this is in the criminal appeal, so not,
Yes, yes.
there are some
My lord.
parameters
Lordship.
within the four corners we have
Yes.
to act. So that is why.
Beyond the evidence, my lord, it will be now difficult.
Okay.
Item number 17.
কুশল কুশলে আমিও লেবো এগুলো।
May I please, your lordship? This appeal is against the judgment and order dated 12/3/2020. Passed by the learned session judge Lakhimpur in session case number 62 of 2017, convicting the appellant under section 302 IPC for life.
At two then. Can we? There are number two. Yes, 13.
Item number 13.
Mr. Ahmed, AM Ahmed was there.
Yes, there. Lordship, I asked for instruction, Lordship. The jail superintendent have said that they have sent some people for verification in the field, whether he is alive or he is dead, Lordship. So now, till now, they have sought for half an hour more. But maybe a date may be fixed because it may not reach
Okay.
Monday,
Whether the person was inside the jail.
Lordship. So for field verification, they have sent someone.
Field verification,
That one I have not understood, Lordship. The
the
jailer
person was inside the jail,
inside the jail.
then
Then
why
maybe
field verification?
they have told the office in charge that verification whether he is dead or alive.
Because as the appellant was in custody,
He was in custody, Lordship.
then why field verification?
That one, Lordship. I also do not got the point why. We have sent the order itself, Lordship, for
1 month almost. 21/6/2024.
Lordship.
Do you have the death certificate?
They also don't have. They have the client. They have not served them the death certificate. They have asked their petitioner to give the death certificate, but they have also not give them the certificate. Actually, it was on our fault.
Certificate to.
Close video file.
Last chance, Lordship. Monday I will produce because they will give after half an hour more.
I heard Mr. A. Ahmed, learned counsel for the appellate, and Mr. M.S.A. Begum, learned additional public prosecutor for the respondent, State also. Post of M.S. Begum has submitted that a report from the concerned jail superintendent is yet to be received, and has commander submitted that case be listed on next week. Next Friday?
Lordship.
26. 07/2024. To produce a report as regards demise of the appellant. The learned counsel for the appellant has also sought 1 week's time to produce a copy of the death certificate. Please the case accordingly also.
Item 17.
May I please, Your Lordship? If I may place the facts in short matter, I've been convicted of killing my wife. The incident occurred in the intervening night of 13/1/2017 and 14/1/2017. I had taken a plea of alibi that I was not in the house. I came in the morning. I knocked the door. Nobody opened. So I immediately went to my neighbor, PW4, asked his help. We both came, opened the door and saw that my wife was dead. She was on the bed. And then PW4 informed PW3. I went 1 kilometer away to inform my brother and his son. Then some villagers also came. Police also came by 7 a.m. Inquest was done by 8 a.m. But and the police found a stick besides my wife, which was seized. And police arrested me that since I was only the person who was residing with my wife in that residence, in that house. So it was only me who could have done it. The trial began by December 2018. 6 witnesses were closed. I examined under 313 in February 2019. The matter was fixed for hearing, but did not start. On 6/11/2019, the public prosecutor made an application before the court saying that we would like to re-examine PW 1, 2, 3, and 4. On 6/11, it was allowed. They were called. On 20/11/2019, PW 1 and 2 were re-examined. For the other two, they were examined on the next day. On the next day, the public prosecutor again made an application that although my minor daughter is not made a witness in the charge sheet, but her evidence should also be recorded. The court allowed it, recorded as CW1. And after conclusion, the learned trial judge took the evidence of the child, my CW1, as the clinching evidence that I was the only person there who could have been there, and I must have killed my wife. That circumstantial evidence was backed by CW1. This was the fact. And as I convicted under 302 for life. Since the day of my arrest, that is 14/1/2017, till today I am in custody, my lord. That is 7 years, 6 months, 5 days. If I may place the FIR, my lord. The FIR starts at page 5. Informant is Manohar Tanti, PW1. The FIR is of 14/1/2017. Sir, with due respect, I would like to inform you that
What is his relation with you?
he is my younger brother.
Younger brother of
Younger
accused.
of the accused. With due respect, I would like to inform you that yesterday, the above mentioned accused person caused injury to his wife, Sumati Tanti, by assaulting her with a stick
over some domestic issue and killed her thereby. The local people were aware that earlier also the above mentioned accused frequently caused injury to his wife by assaulting her, and that about 6 months ago, the accused set fire to her hand. Therefore, we suspect, lots will mark that point, we suspect that last night he had assaulted his wife to death with a stick. In the morning, we saw the dead body lying inside the accused person's house. Therefore, I request you to take necessary action in this regard. This case was registered as North Lakhimpur PS case number 56 of 2017 under 302. I was arrested on the same day, which will be proved by PW6, the IO matter, his evidence.
Let us see the doctor first.
Doctor? PW5 case 20. On 14/1/2017, I was working as medical officer and health officer in so. On that day at about 10 a.m., I had conducted postmortem examination upon the dead body of Kumoti Tanti, aged about 40 years, wife of Sri Arun Tanti of village so. On being produced and identified by UBC 603, Sri Ashok Kumar Shah, and also presence of Sri Novin Porok and Sri Manohar Tanti, both relatives of the deceased Sumati Tanti, and my postmortem examination report is as follows. The external appearance, he says, condition of the subject stout, emaciated, decomposed, etc. An average built female, non-decomposed dead body with rigor mortis present in the limbs. Rigor mortis has started. Wound position was, he says, lacerated wound in the right molar region, 5x4x3 cm. Lacerated wound on the forehead, left side of so-and-so. So injury was on the molar, that is cheek, and on the forehead on the left side. Bruise is nil and so-and-so. There is a fractured skull on left forehead. Membrane was ruptured, brain ruptured. Muscles, he says, clause 5. Fracture left wrist joint, fractured right tibia with fibula, mid third, and fractured femur, left side upper third. Dislocation, he says, fractured serum upper third, fractured right side rib, third, fourth, fifth, sixth, and seventh rib, fractured left. So the chest area was fractured. So he further says more detailed description of the injury or disease. And
Fractures are many parts.
In many parts, but on the upper part of the body.
No, femur also, femur, right tibia, fibula, left wrist joint.
Those are hands.
Third, fourth, fifth, sixth, seventh rib.
Rib, chest.
Right side, fractured sternum, upper third, fractured left side rib, third, fourth, fifth.
Chest
So
area.
basically,
he might have been eating.
homicidal in nature.
Homicidal.
No doubt.
No. So in his opinion, he says, in my opinion, cause of death was due to cardiorespiratory failure due to head and chest injury, due to trauma, which was homicidal in nature. Exhibit 2 is the postmortem report and so on. So there is no contradiction. In cross-examination, he says, I did not mention in my postmortem examination report about the nature of weapon used in committing the assault upon the dead body of the deceased. I did not mention the name of the staff who had been engaged with me at the time of the postmortem examination. There were two staff along with me at the time of conducting the postmortem. From his evidence, it is not proved at what time the death was occurred, approx time, or what weapon was used. But the injuries says that it was homicidal in nature.
Oh, yeah, notice one. Hey, hearing.
I'll place PW4 first, as he was the first person with whom I had interacted. Is at page 17. He is Sri Nabin Horo. If you lordship will see the sketch map at page 70, the place of occurrence is A, and E is PW4's house. So he says, I know the accused, Arun Tanti, who has been present in the accused dock. The house of the accused, Sri Arun Tanti, is situated near my own house at village so-and-so. The deceased Sumati Tanti was the wife of the accused, and she has passed away. The occurrence had taken place 1 year back in the night. I had not seen the occurrence. On the following morning of the occurrence, accused Sri Tarun Tanti came to my house and called my wife, Istar Khoro. Then I went to the accused Sri Arun Tanti. The accused Arun Tanti stated to me that his wife has been passed away in his house. Then I went to the house of the accused, Arun Tanti, and found the dead body of his wife, Sumati Tanti, has been lying on the bed in his house. The lordship will mark this, that she was lying on the bed, and found some injuries on the neck and legs of the deceased. There is no injury found by the doctor on the legs, madam. Thereafter, I came back from the house of the accused, and I saw from my house that the police had come into the house of the accused and had taken away the dead body of the deceased. I also saw the police taking away the accused along with them. I did not know who had caused the death of the deceased, Sumati Tanti. In cross, he says, the police had recorded my statement. Both the accused and his wife, Sumati Tanti, were dead drunkard. I had not stated before the police that I had seen injuries over the neck and legs of the deceased, Sumati Tanti. Thereafter, place PW1, my lord. Page 10. He is Manohar Tati, my younger brother. He says, I know the accused person who is my elder brother. The deceased Sumati Tati is the wife of the accused. On the last Magh Bihu, the accused Arun Tati came to our house and informed that his wife, Sumati Tati, had died. Thereafter, I, along with some other villagers, rushed to the place of the occurrence, and saw that the deceased was lying on the ground, and blood was oozing out from the deceased body, and also saw one wooden lathi lying besides the dead body. The accused was found in a drunken condition, and he could not speak. Thereafter, we informed the incident to Lilabari Police Outpost. Exhibit 1 is the Ezahar. Thereafter, the police came to the place of occurrence and asked about the occurrence. As there was no other person in the house, so my elder brother might perhaps be committed the crime. In cross, he says, I do not know how the occurrence took place. Police has seized one wooden lathi. I do not know whether there was quarrel between the husband and wife. I do not know whether the deceased Sumati Tati had killed herself by consuming mud. He's saying that the accused was drunk. He was unable to speak, whereas the accused himself went 1 kilometer to his house to inform him and bring him here. The first two lines itself, it says that Arun Tati came to our house and informed that his wife had died. I went there. I went there, informed him, and he, along with some other villagers, came with me back to my place.
Yes.
However, no time has been mentioned at what time I went there. Now I'll place PW2, my lord.
Yes.
PW2, my lord, page 12. He is my nephew, son of PW1, my lord. The complainant is my father. And I also know the accused, Arun Tati, who is my elder father. On the previous day of Magh Bihu, Arun Tati came to our house and stated that his wife Sumati Tati had passed away on that day. After hearing the news, my father, along with some other persons, rushed to the house of Arun Tati and saw the dead body of the deceased Sumati Tati, which was lying in the room. And I came to know that on the previous night, the occurrence took place. I cannot say as to who had killed Sumati Tati. I do not know who committed the crime. So he's corroborating the statement that I went to their house, informed them, and his father, along with some other villagers, came to my place and found the dead body lying on the floor.
Yes.
PW3, my lord, thereafter. Page 14. Here's Rajesh Telenga. I know the accused Arun Tati, who had been present in the accused dock. The house of the accused Arun Tati is situated half a kilometer from my house in the same village. The deceased Sumati Tati was the wife of the accused. Sri Arun Tati, Sumati Tati had passed away. The accused was a habitual drunkard. The occurrence had taken place about 1 year back in the night at about 10:11 p.m. At the time of the occurrence, there was Magh Bihu, and in the night of the occurrence, I heard hue and cry towards the house of the accused. On the following morning of the occurrence, one Nabin Horo, his PW4, whose house is situated nearby the house of the accused, informed me over phone and that some untoward incident happened in the house of the accused, Arun Tati, and asked me to come to the house of the accused, Arun Tati, along with some other persons, then some other persons. Then I, along with 15 to 20 persons, went to the house of the accused. When we reached the house of the accused, Sri Arun Tati, we found the dead body of his wife had been lying within the house. We also found the accused, Arun Tati, in his house. Then the incident was informed with Lilabari police outpost. Then the police from the Lilabari police outpost came and took the dead body of Sumati Tati by an ambulance and also arrested the accused, Arun Tati, and took the accused along with them. I do not know who had committed the murder of Sumati Tanti. The police had interrogated me. In cross-examination, he says that I had not given my statement before the police. I do not know who had committed the death of the Sumati Tanti. PW 2, 3, and 4 do not say anything about the lathi which was found. Only PW 1 says. PW 5, the medical officer, I've already read mine. Then PW 6, the IU. Page 23. Is Inspector Lintu Bora. He says, on 14/1/2017, I was working at Lilabari Police Outpost under North Lakhimpur Police Station as in charge. On that day, Shri Manohar Tanti, PW1 of so-and-so, lodged an Ezahar with Lilabari Police Outpost, stating inter alia that on 13/1/2017 at night, the accused Shri Arun Tanti committed murder of his wife Sumati Tati by comedic marpit with a lathi upon her person. On receiving the Ezahar, I made GD entry by Lilabari Police Outpost, GD entry number 200 dated 14/1/2017. This GD entry is not made a part of the trial matter. And forwarded the Ezahar to the OC North Lakhimpur for registration of the case under proper sections of law and entrusted me with the charge of investigation of the case. After receiving the charge of investigation, I visited the place of occurrence, which is the house of the accused, Sri Arun Tati, situated at so-and-so. I prepared a sketch map of the place of occurrence. I found the dead body of the Sumati Tati had been lying on the ground in the house of the accused, Sri Arun Tati. I found that there was bleeding from the head of the deceased Sumati Tati. When I reached into the house of the accused, Sri Arun Tati, I did not find any person. After my arrival in the place of occurrence, Sri Ramesh Tati, Manohar Tati, Jadav Tati, Rajesh Telanga came to the place of occurrence. When I reached into the house of the accused, I did not find the accused Arun Tati in his house. After some time, accused Arun Tati came to his house. Now he further says that I found a stick like branch of a tree in the house near the bed of the accused, Sri Arun Tati, and I seized the same by preparing the Caesar list, Exhibit 3. Is the Caesar list of the stick like branch of the tree. I conducted the inquest upon the dead body of the deceased, Sumati Tati, and prepared the inquest report. The inquest report of Sumati Tati and the Exhibit 4 is the inquest report, and Exhibit 4.1 is my signature. I have recorded the statement of the witnesses under Section 161 CRPC. I arrested the arrested accused Arun Tati. Thereafter, I forwarded the dead body of Sumati Tati at North Lakhimpur Civil Hospital for postmortem examination. I came back at Lilabari Outpost along with the accused Sri Arun Tati. After postmortem examination, the dead body of the Sumati Tati was handed over to the relative of the deceased Sumati Tati. On the following day, I forwarded the accused Sri Arun Tati before the court. I collected the postmortem examination report of the deceased Sumati Tati from North Lakhimpur Civil Hospital. After completion of investigation of the case, on being sufficient materials under 302, I submitted the charge sheet against the accused under Section 302 IPC. Exhibit 5 is the charge sheet. Exhibit 6 is the sketch map. So if I may place the inquest report and the Caesar list.
Yes.
The Caesar list at page 61, my lord. So I so-and-so do hereby seize the following below noted article in connection with the above referred case. in presence of witnesses and so and so. Date is 14/1/2017 at the house of the accused. Time of seizure is around 8:40 AM. The description is a wooden stick measuring about 3 feet long. It doesn't say that there was some blood, nothing. It was not even sent to the forensic to get the fingerprints or the blood, whether it belonged to the human. Nothing was done. It was simply seized, and this was not even produced before the court. Only the seizure list was produced. Now the inquest report, ma'am, page 63. It was done by the Ayub. He says, as per the order of the district magistrate Lakhimpur, not Lakhimpur, White so and so, I so and so of hereby conduct an inquest over the identified at 7 AM in the presence of Sri Manohar Tati. The deceased died on 14/1/2017 in encounter of committing suicide by so and so. It must have been the format in which he has written. So the inquest report, he says, identification of the dead body is Sumati Tati in her house, present house, lying at the house. The dress was brown color and so and so. Height was around 4.5 feet. Injury, if I may please, my lord. Serial number 4, body built. It says black injury mark. Then serial number 8, mouth, there was some injury, neck, head, hand, chest. So serial number 4, 8, 9, 10, and 11, there were some injury marks. And inquest was completed at 8 AM. So after the inquest, he seized the lathi at 8:40. And he has not spelled out that blood was oozing or anything. There is nothing in the inquest report. Yes. Thereafter, my 313 statement was recorded on 26th of February 2019. That is at page 27.
Yes.
It was complete denial, my lord. Except I'll place question number 10 at page 29. PW4 Naveen Horo in his evidence stated that then he went to your house and found the dead body of your wife, Sumati Tanti, had been lying on the bed in your house. Have you anything to say on this point? He says, yes, I, along with Sri Naveen Horo, came to my house. The door was locked from inside, and we called my wife, Sumati Tanti, by her name. As she did not make any answer, I broke open the door and found my wife was lying dead on the bed. And question number 15, my lord. Have you anything more to say? Then I say, I have one son aged about 12 years at present and a daughter aged about 8 years at present. They have not been living in my house. At the time of death of my wife, I was not in my house. I was at Rajgarh under Arunachal Pradesh, where I was working as a laborer in the house of an Arunachali. So this is the alibi that was taken, but I didn't produce any other corroborating witness matter to that effect. The evidence was closed. Matter was fixed for hearing, but for more than 7 months, 9 months, the hearing could not be started. The PP on 6/11, the order sheet is there, madam. On 6/11/2019, made an application before the court that he want to re-examine PW 1, 2, 3, and 4. Which was allowed, and PW 1 and 2 had been examined on 2011/2019. The re-examination part, if I may please, page 11, my lord, PW 1 re-examination. He says, I saw the injuries over the whole body of the deceased Sumati Tati, the wife of the accused Arun Tati. Besides the dead body of the deceased Sumati Tati, there had been lying a lathi stained with blood. There was injuries over the face of the deceased Sumati Tati. Blood was oozing out of from the injuries of the deceased Sumati Tati. At the time of occurrence, I had been living with my family in the separate house from the house of the accused. My house is situated around 1 kilometer away from the house of Arun Tati. The accused Arun Tati at the time of occurrence had his wife and 2 daughters. And the time of occurrence, the elder daughter of the accused, Sri Arun Tati, had been married and his younger daughter was a minor one. At the time of the occurrence, the elder daughter of accused Arun Tati was in the house of her husband. At the time of the occurrence, the family of the accused consisted of his wife and his minor daughter, Ruma Tati. I do not know whether Ruma Tati, the minor daughter of the accused, was in the house in the night of the occurrence. The accused Arun Tati had a son who had since before the time of occurrence had been living as Gharjamai in the house of his father-in-law. In cross-examination, he says that I had not stated to the police that the blood was oozing out from the injuries of the deceased, Sumati Tati. I had not seen the commission of the marpit by the accused Sri Arun Tati upon the person of his wife, Sumati Tati. At least all the re-examination first, then I'll make my submission, madam. Then PW2 at page 13, madam. Both this PW 1 and 2 were re-examined on 2011/2019. At the time of occurrence, I was living with my father, Sri Manohar Tati, PW 1, in our house, which is situated about 1 kilometer away from the house of the accused. On hearing the death of my aunt from her husband, my uncle so-and-so, I went to his house in the morning of the following night of occurrence. I found the dead body of the deceased Sumati Tati was lying in the room of the accused, Sri Arun Tati, and there were injuries over the face and hands of the deceased Sumati Tati. I saw blood oozing out of the injuries. I did not like to see the other parts of the body of the deceased Sumati to see the injuries, if any, sustained by her. At the time of occurrence in the house of the accused, Sri Arun Tati, there was only his wife. On the night of occurrence, the minor daughter of the accused had been in the house of her grandmother, which is situated around half kilometer away from his house. The accused Sri Arun Tati has 2 other daughters and 2 sons. The aforesaid 2 daughters and 2 sons of the accused had been married before the occurrence. On the night of the occurrence, the both married daughters of the accused, Sri Arun Tati, was in the house of their husband, and both sons and accused, Sri Arun Tati, had left his house since prior to the occurrence. As one son of the accused had been living as Gharjama in the house of his father-in-law, and the other son had been living with his wife in the house of our grandmother. The accused Sri Arun Tati, along with his wife, Sumati, was living in the house alone. There is no other family member or family in the homestead of the accused Sri Arun Tati. In cross-examination, he says, I had not stated to the police that I had seen the injuries over the face and hands of the deceased Sumati Tati. I had not seen the commission of the occurrence. On the next day, 21/11/2019, PW 3 and 4 were re-examined. What they say, PW 3 is page 69. When I reached PW 3, when I reached into the house of the accused Sri Arun Tati, I found the dead body of his wife had been lying within the house of the accused. I had not entered into the house to see where the deceased Sumati Tati had sustained injuries, as because I became nervous on seeing the injuries on the person of anybody. For this reason, I had not gone to see in which part of the body deceased Sumati Tati had sustained injuries. The accused Sri Arun Tati has all total 5 offsprings, out of whom 2 sons and 3 daughters. The elder son, namely so-and-so and so-and-so, had been married and has been living since before the date of occurrence with his wife at Siloni Bari. The other son, at the time of the occurrence, had been living in the house of the accused. He had been living in the house of Sri Nibhas Hembram since before the occurrence in my village. Out of the 3 daughters, the accused Sri Arun Tati, 2 daughters had been married since before the occurrence, and at the time of occurrence, they were in the house of their husband. The accused Arun Tati had a minor daughter, namely Ruma Tati, who at the time of the occurrence was living with her elder sister in the house of her husband. And the cross-examination will be declined. Then PW 4 was also re-examined at page 19. So he says, when I went into the house of the accused Arun Tati, I found his wife Sumati Tati had been lying dead on the ground near the bed. I had seen bleeding injuries over the legs and stomach of the deceased. I had seen a lathi situated by the side of the dead body of Sumati Tati being smeared with blood. My house is situated nearby the house of the accused, Sri Arun Tati. On the night of the occurrence, the accused Arun Tati and his wife Sumati Tati were only in the house of the accused Arun Tati. So in cross-examination, he says that I had not stated to the police that I had seen the lathi situated near the dead body of the deceased, Sumati Tati, being smeared with blood. On the same day, my minor daughter was also examined as CW1. Her examination is minor. Page 25. Her age, my lord, on the second line, aged about 12 years.
Page?
Page 25. She is a minor, 12 years.
12 or 17.
12 years, my lord. And I do not find the requirements of 118, my lord, to see whether she could understand the question and answer correctly. That has not been followed here. Of the evidence check, my lord, 118. She says, the accused Arun Tati is my father. This is Sumati Tati was my mother. My mother was passed away around
What
2
is
years.
11B? 1 and 8?
118. Who can testify, my lord? So it says, all persons shall be competent to testify unless the court considers that they are prevented from understanding the questions put to them or from giving rational answer to those questions by tender years, extreme old age, disease, whether of body or mind, or any other cause of the same kind. So when a child witness comes in, normally 4 or 5 questions are asked to them to see whether they can understand and they can answer the questions. And thereafter their evidence is taken.
How fatal it is? How fatal?
May not be fatal in my case because she has not stated anything of that sort. She was not there. She simply said that my mother and father resided at that house. And she was residing with her grandmother. She was not here. To say that on the night of the occurrence, I was there.
What is the observation regarding CW1 by the law and trial court?
Right.
How he discussed?
Right. My lord, at page 45, paragraph 20.
Yes.
Somewhat around 12 lines from the below, my lord. His minor daughter is a witness. In the middle. His minor daughter is a witness and she clearly testified that her father and mother were in the house at the time of the incident. No alibi was produced by the accused in support of his denial and so and so. Then there is clinching evidence that the accused was alone in the house at the time of the incident. The evidence of PW 2, 3, 4 and CW1 clearly depicts that the accused person's minor daughter who resides with him was with her grandmother at the time of the incident. Why was the lathi found beside the accused person's bed? And then in paragraph, last 4 lines on paragraph 21, my lord. It has to be borne in mind that CW1 is a child of only 12 years. She would definitely not implicate her father if he is innocent. Her evidence
Which
affirms-
page? Which page?
Page 46, paragraph 21.
Yes, which line?
Last 7 lines of paragraph 21. It has to be borne in mind that CW1 is a child of only 12 years. She would definitely not implicate her father if he is innocent. Her evidence affirms that while she was staying with her grandfather, her parents were alone at home. I would like to rely on the decision of so and so. And then paragraph 22. Reverting back to this case, it is held that the explanation offered by the accused was found to be untrue, and this has become additional link in the chain of circumstances. The other circumstances against the accused is that evidence of all the witnesses clearly depict that he was with his wife at the time of the incident. PW1 testifies that the accused was inebriated when he went and informed him that his wife passed away. PW1's evidence is similar to his FIR. The cross-examination of PW4 also clearly depicts that the accused and his wife are both alcoholics. This explains the innumerable injuries detected on the victim's body. The injuries detected by PW5 on the victim's body clearly depicts that she was stressed by a person who appears to have been possessed by rage. And paragraph 24 last. In the instant case, there is no possibility of any other person getting access to the accused person's house. The victim was found dead inside her house. There is clinching evidence that the victim resides in the house with her husband. It is held that the accused was last seen with the victim. Thus, it can be safely held that the accused and only the accused committed the murder of his wife by causing the injuries on her head, brain, and chest area, which are sufficient to cause death. The accused was aware that such injuries were sufficient to cause his wife's death. This case is deferred so to sentence part, for the sentence part. Now, the stick that was found and seized was never produced before the court. It was not sent to the forensic to ascertain whether it was used, actually used, for commission of that offense? Or it was used by me? They have not seized the wearing apparels. If I had fetched her, some blood stains might have been fallen on my clothes. Those were not seized. Nothing was sent to the forensic. In the first part of the examination, everybody said that we presume it might have happened, that the appellant has caused his wife's death. One person said both of us drink and then we quarrel. One of them have said that I had burned my wife's hand. But the doctor's description of any injury doesn't say that there was any burnt mark on her hand. He didn't find anything of that sort.
That was prior to the occurrence.
Maybe, but when he checks the body, he gives injury marks.
meantime,
It's so and so
might
part of the body, so and so injury is there. Old injury, he may write it. Because he writes healthy, this part is okay, the organs are good.
But it is established that on the relevant night, you and your wife were in the house only.
Now, the person who has said that, PW3.
Yes,
PW3 says, I heard
even
coming
CW1
from that
also.
side. Where he was standing,
No,
he
even
doesn't say.
CW1 also stated that on that night you and your.
CW1 category.
CW1 says that I was at my grandmother's house. That is half a kilometer away.
That
See-
part of evidence remain unrebutted.
See-
in those
say-
examinations.
She can only say that, yes, my mother and father reside at that house. They are the only person. My
Those
siblings, they
taken
do not reside
The
there.
plea of alibi in the P13 statement, you have not adduced evidence.
I have not-
PW4 was
corroborating
never put a
evidence I have not.
question that you and PW4 had to break open the door.
PW4 didn't say that.
You did not say that, you did not put anything to PW4, that you and PW4 together broke open the
The door.
door. It was not there. It was there only in
3:30.
313.
Now, PW3 also says that he heard some
went back.
quarreling coming from that side. He doesn't say that it was in my house itself.
PW4 also says, as there was no other person in the house. So my elder
So
brother
PW1
might perhaps be committed the
So
crime,
PW1 resides 1 kilometer away.
right? But even
They
he
all
says,
say that only 2% reside in that house. So nobody else could have done it.
every witness was saying that you and your wife were.
We only reside in that.
What you have asked to CW1 also?
He says, I had met the police in the house of the father so and so. The police had not asked me anything. I also had not stated anything to the police regarding the death of my mother. My mother, Sumati Tati, used to take alcohol often. When my father, Sri Arun Tati, and mother were under the influence of alcohol, they used to quarrel.
Now,
So these
If a-
people.
in the
and-
case of circumstantial evidence, if the prosecution proves the chain of circumstance and the accused takes a plea of alibi, and if that fails, then becomes one more additionally.
But still the burden remains on the prosecution to complete the chain,
Now,
that whether I was actually in that house when the incident took place.
PWs were consistent that you and wife
Resided that
resided
house.
together.
Reside together in that house.
Now, not a, that
We drink, we
breaking
quarrel.
open the door, it was never there.
It was never questioned.
You could have lead defense evidence also.
Now, first time when
That
PW
where you were there, because alibi is to be proved,
by me,
not by this preponderance of probabilities, It has to be with
Proved by some
certainty.
person.
And if it fails, then again it becomes, the prosecution case becomes more stronger.
Now, the day the offense occurred, the next day immediately I was arrested at 8 a.m. I was in jail till today. I am there. There is nobody to support me there also. Even during the trial, there was legal aid counsel. My family members, my brother, he is giving a statement against me.
He is not, he has deposed the facts. And the suspicion he has
And he is
expressed,
presuming.
suspicion he has expressed
Madam,
appears to have some basis. As there was no other person in the house, so my elder brother might perhaps. He is truthful to that extent. PW1,
PW2,
PW2, they are truthful to that extent. And it is lying inside the room or house. At least inside the house.
inside the house. It is inside the house.
Other than that,
According to me, the chain is not complete. So Birdi
which part?
that
Homicide
actually-
is
homicide it is.
not disputed.
I'm not disputing that.
Now the assailant.
Who has done it? Whether I was present there or not. That has not been proved by the prosecution. That is what I'm saying. And for that, I am placing my Birdi chance that the chain has to be complete. And then another decision, my lord, Shivaji Sahab Rao, to say that the primary principle that the accused must be and not merely be guilty. They have to state by clinching evidence that it was only me and nobody else, and not just saying that maybe I was the only perpetrator of the.
See, your son has become Horjaman. He lives elsewhere. Your elder daughter is married elsewhere. Your younger daughter stays with grandmother. Your elder
I have 5 children.
brother,
2 sons married, 2 daughters married.
yes.
The
So
only-
remaining is you and your wife and your immediate neighbor. Suppose on the 13th of January, you did not come out of your house. Where the prosecution, the IO, officer in charge of that police station can bring evidence.
He had that.
You have to be,
He had that stick.
stay in the
have
reality
to-
also.
He could have taken my clothes. The blood stains must have been there.
Huh?
The blood stain must have been there.
Blood stain. Who's blood stain?
If I am hitting somebody with a stick of 3 feet,
Huh.
the blood would spring on me. There has to be some blood.
And you don't have time to wash your hands. That is Sarda Birisan.
That is paragraph 153 and 154.
Yes. So far as husband and wife is concerned, there are other decisions also.
And paragraph
Husband and wife is concerned, it is locus classicus. There is no doubt about Sarda Birisan. But now the special case is husband and wife now.
So in
There
any
is a
case,
circle.
in any case, if a husband and wife,
The center is now husband and wife.
so can, in any case where a husband, the wife has died and the husband is there, will it always be presumed that he has done it?
No, that is why we try to examine that
So-
whether there are
so-
any other inmates,
No,
whether there were other inmates.
there were no other inmates.
Then your story about breaking open, that also absolutely there is nothing. It
I
is
do not
an
have any corroborative evidence.
afterthought. There was no cross-examination. PW4 should have been cross-examined. It is not that State Defense Council
Could not have.
is not permitted to visit and consult accused. That right to consult was there. But he did not visit or did not consult is another thing. Right, that cannot be taken. I know. You need to visit to right to us. জেলও তো ভিজিট করে পারে
বা যেতে বলবো তাহলে
তেটিও পারে with sincere legal aid counsel is the duty. Should have done it. That is, they don't visit, that is another thing. But right to consult was always there. That was not curtailed.
This person is a laborer, my lord. He says he's a laborer. He may not understand how he can consult or he can call his lawyer to the jail.
Had some ground been there, he could have at least suggested. Even suggestion was
Suggestion was
not
also not there.
there, at least to infer what was the defense story. There was nothing, no suggestion even.
No, sir. Except that PW4, when he first came, he saw the dead body on the bed. There was no blood, nothing. But later on, when other people came in, they saw the dead body on the floor.
But fact of the matter, the
So,
dead body was lying
police of
inside
the-
the house.
The incident took place inside the house.
And whatever was there, by re-examination, prosecution has strengthened its story. You want to say explanation? Explanation देखो नहीं. Explanation
আর যেটা দিছে এটা false.
false. And if the explanation is false, that goes against
By
you.
them, it was only proved that the stick was inside the house. But whether the stick was actually used has not been proved. Whether it was used by me has not been proved. The rigor mortis has already started by the time it was taken for postmortem. And if the incident had taken place at night, blood could not have been oozing at that point of time in the morning. It must have been dried.
There should have been some explanation that
Which
you
they-
were there somewhere else. Your friend, Mr. X's house. No explanation. I was not in the house.
Or my employer.
I was not in the house. That's all. And postmortem report says that assault was not once,
Not once. It could not have been once.
multiple assault. Intention to commit murder was there, and no exception. You have, that is unfair advantage. Unfair advantage, whatever be the weapon of assault. It is not always necessary to examine. I am responsible. I do not know how she sustained injuries. I am innocent. I have described that I was not present in the house on the day of Arunachali Basti. You were Arunachali Basti.
In a house of Arunachal. At
I was staying alone. But the door was not opened by your wife,
It was
or
not-
door was closed. That was also not, that
I
did not
didn't read.
emerge to be a true one.
Fact remains that I informed the PW4, PW1 and PW2. I went 1 kilometer there also to inform them.
I asked to inform. Or deeper. BT Sun. Yes, Shivaji, one which paragraph?
Paragraph 19, madam.
19.
This has been reiterated in Birdichan. Shahadul.
But Shivaji is
Later on.
Shivaji is a case of single eyewitness. But BD Sun, paragraph 53 onwards, it is on
153?
circumstantial evidence.
Yes. This has been
Huh.
reiterated.
Maybe true, maybe must be true. That was
That has to be
taken
into consideration.
followed. But so far as this husband and wife residing in the same house, the principle incorporated in section 106, Evidence Act, also comes into picture, comes to the fore. There you owe an explanation. And even explanation is not there, but a plea is taken, alibi. That has to be proved with certainty. And if that falls, then that will be an additional circumstance, adding to the weight of the circumstantial evidence. আহিছে নেকি কথাটো ক'ৰবাততো হেৰিত লিখিছিল ক'ৰবাত এই ডাংকাৰটোতো লিখিছে এফআইআৰত লিখিছে assaulting her. Well,
CW1.
Everybody said
I know.
that in the house, the accused and the deceased used to reside together,
Together.
right?
Lordship.
The incident happened in the night intervening 13th January and 14th January, Magh Bihu time. One of the submissions might perhaps be that 13th, he was not there.
Lordship.
And on 14th morning, he came
Yes.
and he sought to explain in 313 that the door was locked from inside in 3:30.
My lord.
And then finding that the door was locked, he went to the house of PW4 and brought him to his house. And thereafter, both of them with the lathi broke open the door. And going inside, he found his wife
Slide.
below the blanket, dead. Now he wants to say that I was not there. Alibi.
Lordship, but PW2, he says, my lord, on the previous day of Magh Bihu, Arundhati came to our house and stated his wife's.
No,
So
that is
what did that-
actually something wrong.
My lord.
That is something wrong. But morning, he went to inform
My lord.
his younger brother,
Yes,
and PW2 is the son of PW1.
Lordship.
Both, right?
Yes.
Both resided together. PW1 was the father of PW2.
My lord.
So he is basically nephew. So younger brother, he used to live at a different place, 1 kilometer
Yeah.
distance. His sons were not there. His daughters were not there. Younger daughter was with the grandmother. PW4 was the only neighbor. Who is PW3? Oh, half kilometer.
And he-
Co-villager living at a distance of half kilometer. But he heard halla. Halla.
Lordship, PW3 also says, third line from the bottom. We also found the accused Arundhati in his house.
There was nobody near neighbor other than PW4.
There were, madam. From this.
Over the sketch, where is the sketch, ma'am?
70,
70.
space 70, madam. This is D,
D,
F,
E,
D,
D,
E,
E,
Rest of
word
cannot
C
exist.
also.
D,
C, D,
D
E.
is one Bireshwar monkey.
He has not been.
Ayamoni Paharia. Nobin Hori is PW4.
Yes.
And A is Arun Tati.
Indicates the
Uh,
place of occurrence. IY house.
C and D were
Not made a
Not
witness.
not-
witness one. Not
Where
exactly.
is the Sarsit?
Shit.
Page 66.
All the listed witnesses were examined.
Examiner. 7.
Quality, not quantity.
Lordship. But Lordship, the explanation offered by the accused person gives an
No,
additional link. He
yes,
could not
That
give any positive
become
evidence.
additional link, whether the chain of circumstances was complete.
Lordship, in a case under this, as is before this honorable court, Lordship, it's not as the case which of general circumstantial evidence, my lord. This is a case which murder has been taken place in the four corners of our house, whereas there is no possibility to witness the occurrence. And when the occurrence had taken place in the wee hours, midnight, my lord, in the night hours, so there is no possibility, your lordship, that the people will lordship. So the inmates of the house are the person who can give the possible explanation. Lordship, but the explanation given by the accused person that he was somewhere else, my lord. At the same time, when the other witnesses are deposed, that he came to report and he was there on the previous day of the Magh Bihu. Lordship, it's false flat, my lord. And to that effect, he could not give any additional evidence, my lord, regarding the plea of alibi. So these are the
No,
circumstances.
plea of alibi, normal principle is that plea of alibi, after, if a case is based on circumstantial evidence, the prosecution is required to prove what is possible to be proved.
So here, possibility,
Right.
Only
Then
factor
if the accused takes a plea of alibi and that emerges to be a wrong one,
my
false
lord,
one,
yes,
then that becomes an additional
evidence,
a link
link to the
adding
chain of
weight to the
circumstances.
circumstantial evidence.
My lord,
That becomes more stronger.
my lord.
So whether this prosecution side had proved all those circumstances which is possible to be proved. Now, though it is homicide, the lathi was seized. Stick,
My lord.
right? You claim that it was the alleged weapon of offense, assault. It should have been shown to the doctor whether these fractures, all these were possible to be inflicted by this stick. That is one which you did not. If it was bloodstained, then this should have been sent for serological examination. Right? That bloodstains
My lord.
belonging to group so-and-so matches with the blood group of the disease.
My lord.
That should have been an additional circumstances.
Please
So
prove,
these
my lord.
additional circumstances are found lacking due to fall in the place of the prosecution, investigation.
Yes, my lord.
Now, whether all these gaps or these lacunas in the investigation will dent the case of the prosecution.
Lordship, because this is procedural lapse, my lord. If your lordship considers the postmortem report, page 59.
Homicide, no doubt.
No, my lord, then fracture, left wrist joint, fracture, right tibia, and fibula major fracture. So there's a possibility, my lord, that has been committed by
Civility, but
possibility.
why not you sent it
Lordship,
for
it's a defect in the prosecution case. my
now?
lord.
Whether that creates gaps?
In normal case of circumstantial evidence, the accused might have got benefit, but if this is a case wherein it has been committed within the four corners of the house. And when the accused did not give any explanation.
Four
to the-
corners, but this lathi is sending the lathi to FSL
My lord,
or showing it, the material exhibit,
my lord.
to the doctor. These are possible on the part of the prosecution.
It was my lord, but
These
lordship-
were possible,
Lord,
which you did not do.
all the cases in go against the
No,
prosecution, my lord.
four corners, okay.
Lordship,
We
my
know
lord.
these are what is possible to be proved. Suppose something has happened inside a house. Prosecution cannot go inside the room that there is a movie Back to the Future and find out everything. But whatever else is possible to be investigated and proved should have been proved.
Lordship, my lord, but the defect in the prosecution case, so for that reason, the.
You,
accused must
okay,
show
so
with
that I
advantage.
hypothetical examination, if this Hira Aruntati, habitual drunkard, remained inside the house all throughout the day of 13th January. And in night, he committed the act of murder. Prosecution will not be able to prove that he was seen by somebody, even by a neighbor, close neighbor. Accept it.
But other
Other,
procedural formalities. they
other,
were
which
not-
is possible to be proved. That was not done.
not- The for that reason, my lord, the accused will not get any benefit. I want to rely on one judgment, Wazir Khan. Already Lordship also.
23, 8 SCC.
Yes.
One zero six.
Para, okay, Lordship, page 8.
Line starts with
In a case based on circumstantial evidence where no eyewitnesses is available, there is another principle of law which must be kept in mind. The principle is that when an incriminating circumstances is put to the accused, and the said accused either offers an explanation or offers an explanation which is found to be untrue, then the same becomes an additional link in the chain of circumstances to make it complete. This view has been taken in the Ketanab decisions of this court in Nikaram versus State of so-and-so, and Ganesh Lal, then so State of UP versus Dr. Ravindran. When the attention of the convict appellant Wazir Khan was drawn to the incriminating circumstances that inculpated him in the crime, he failed to offer appropriate explanation or gave a false answer. The same can be counted as providing a missing link for completing a chain of circumstances. When an accused is alleged to have committed the murder of his wife, and the prosecution succeeds in leading evidence to show, like in the present case, that shortly before the commission of the crime, they were seen together. Lordship, in our case, he was not seen, or the offense took place in the dwelling house where the husband also normally resided. It has been consistently held that if the accused does not dispute his presence at home at the relevant time and does not offer any explanation how the wife received injuries, or offers an explanation which is found to be false, it is a strong circumstance which indicates that he is responsible for commission of the crime. Lordship, that page 10, down below. If an offense takes place inside the four walls of a house and in such circumstances where the assailants have all the opportunity to plan and commit the offense at a time, in the circumstances of their choice, it will be extremely difficult for the prosecution to lead evidence to establish the guilt of the accused. If the strict principle of circumstantial evidence is insisted upon by the courts, reference could be made to a decision of this court in the case of Trimukh Maruti Kirkan versus State of Maharashtra, reported in 2007 Criminal Law Journal page 20, in which this court observed that a judge does not preside over a criminal trial merely to see that no innocent man is punished. This court proceeded to observe that a judge also presided to see that a guilty man does not escape. What are public duties? The law does not enjoin a duty on the prosecution to lead evidence of such character, which is almost impossible to be laid, or at any rate extremely difficult to be laid. The duty on the prosecution is to lead such evidence which is capable of leading, having regard to facts and circumstances of the case.
Here, that if an offense, last but one page, if an offense takes place
Of my lord.
inside the four walls of a house, and in such circumstances where the assailants have all the opportunity to plan and commit the offense, at the time and in the circumstances of their choice, it will be extremely difficult for the prosecution to lead evidence to establish the guilt of the accused if the strict principles of circumstantial evidence is insisted upon by the court. Then Trimukh Marathi was referred. It will be said, a judge does not preside over a criminal trial merely to see that no innocent person is punished. This court proceeded to observe that a judge also presides to see that a guilty man does not have. Very principle of very good way.
The plea of alibi, 2010, I don't have the book today. 2010 8SSC 430, other day submitted by me, para 30 to 36. On the plea of alibi, madam. 2010 8SSC 430, para 30 to 36.
DD pilot DD.
Sheikh Sultan versus State of Maharashtra.
But it says that if the plea of alibi is not proved, that becomes additional circumstance. And what is the standard required for plea of alibi?
No, I don't have book today, my lord. The positive evidence has to be today, that my lord. You asked.
Oh, you have
From my diary. I'm
without seeing the
No.
content.
So,
Oh, that is not acceptable.
In fact, in Wazir Khan, that
Huh?
23(8), in paragraph 25, it's from Supreme today, my lord, I don't know. It says, where an accused is alleged to have committed the murder of his wife, and the prosecution succeeds in leading evidence to show, like in the present case, that shortly before the commission of the crime, they were seen together. Or the offense took place in the dwelling home where the husband also normally resides. It has been consistently held that if the accused does not dispute his presence at home at the relevant time and does not offer any explanation how the wife received injuries or offer an explanation which is found to be false, it says it has to be found to be false or to be proved to be false. It's
Plus,
unsubstantiated.
what is the standard required for proving a plea of alibi? That is on what that point. And if that falls, there are many judgments. Then it goes
Then it-
against the accused.
then it- if it remains unsubstantiated, it's against it.
Okay, heard Mr. B. Prasad. Amicus?
Amicus.
Learned amicus give it for accused appellant and MS BVN learned additional senior counsel and additional public prosecutor assisted by MS R. Das learned counsel for the respondent state. Most of arguments are heard. The husband is read. Taken care of. I would remove. You were too but then police was little latest, no? We kind of award. Well, rice that is single man's. What's the? Yes, you have anything? How many years? Detention?
6 years, sir.
6.
It's a lifetime here.
Oh,
no.
inside the jail.
3 years, 4 months, 22 days. Lordship, in this case, my learned friend is waiting for informant, he has not received the paper.
For the informant,
Ah,
I have not been supplied with the copy of the paper book.
okay, Mr. BN, Dr. BN Gogoi, learned amicus curiae for the appellant. Miss B. Bhuiya, learned senior counsel and additional public prosecutor. For the respondent number 1, State of Assam, and Mr. J. Das.
S.H. Mahmood.
S.H. Mahmood, learned amicus curiae for the respondent number 2 are present. First of Mr. Mahmood, learned amicus curiae for the respondent number 2 has submitted that he has not yet been has not received a copy of the paper book till date. First of office to furnish a copy of the paper book to Mr. Mahmood, learned amicus curiae for the respondent number 2 within a week from today. Release the case appeal after a week on a date to be fixed by the office. Mr. D. Das, learned senior counsel, assisted by Mr. N. K. Mohammed, learned counsel for the petitioner. And Mr. P.P. Dotto, learned counsel representing Mr. T.J. Mohanto, learned senior counsel and standing counsel GH are present. Mr. Dotto has submitted that the counter affidavit on behalf of the respondent number 4 and 5 is in the process of vetting and has sought for listing of the case. After 2 weeks, first of the prayer is allowed, list the case on
7th August.
for filing of counter affidavit by the respondent number 4 and 5. The interim order passed earlier shall continue till the next date of listing.
Item 2. That's the same. Actually, what we said, there was an interim order. There was no interim order. But what we said to the court earlier, they let them file a response so that it will be easier for the
Yes.
court also to us also.
We keep it on the same date.
Yes. Actually, they should file it. Otherwise, they will continue and this person will retire. They will.
Anyway, in charge basis, will not get any benefit, I think. Finally, when he is.
I don't know when he is going to. But what I felt, there was some more there was competent and eligible candidate also. Normally, lot of cases are being dealt by your lordship and found that there are more eligible. If there were no eligible, then the situation would have been different.
But that eligibility question, that whether the first, actually, this also hinges with the
First case.
first case.
Yes.
If he is eligible, suppose, I don't know.
No, the eligibility is one of the criteria. Whether he can be brought from the
That is,
outline, that's the whole case.
that is
He
the
may
crux.
be eligible.
That is the crux.
Crust of the case.
Then he will also become eligible.
Yes, right. If it can be brought from the outlying benches, then he may be eligible. That's it. First, whether he can be brought.
That is
He will be
the
eligible.
crux of the
That's the
issue.
whole case.
Mr. Dasim, I got to understand. As sought for by Mr. Dotto, learned counsel for the respondent number 4 and 5, lays the case on same date,
7/8.
So
7/8, you know?
7 August.
When I was keeper.
7. आज की तारीख?
So if they give the copy, my lord, in advance, then it is,
Yes, make sure.
that's.
Put it on 5/8, 5/8 or
5/8.
7/8? 7/8.
Whichever is convenient.
7/8.